Good morning and welcome to the Tennessee Court of Appeals. First of all, I want to thank you for participating in this live streaming video argument. I know it's not the norm, but it may be. Who knows? Obviously, we have no idea going forward, but we appreciate you participating in it. It's our best way of trying to keep everyone safe, but yet continuing to process the cases that come through the system. So we very much appreciate you taking the time and making the effort to participate in this. Before we get started, let me introduce your panel for this morning. Your panel will consist of Judge Arnold Golden from Memphis, Judge Karma McGee from Savannah. I'm Steve Stafford from Dyersburg. Obviously, both of you are experienced practitioners. You've been here before, but the basic ground rules are each side gets 15 minutes to make its oral argument. If you're the appellant and you wish to reserve any rebuttal time, please request that from the court after you've introduced yourself and before you begin your oral argument. Obviously, appellee gets no rebuttal time. Having said that, I don't think there's anything else we need to go over. So, Ms. Tibner, if you would call the first case, please.
Tkach Stokes versus Allenbrooke Nursing and Rehabilitation Center, LLC.
All right, we will hear from the appellant.
Good morning. I'm Brett Seiler, and I'm here on behalf of the defendant and the appellant, Allenbrooke. I'd like to request 2 minutes for rebuttal, if it please the court.
All right, sir. You may proceed.
May it please the court, this appeal is from the denial of a motion to compel arbitration that my client filed. The trial court denied that motion. This is a case arising out of a nursing home admission. The trial court denied Allenbrooke's motion to compel arbitration because it found that Mr. Stokes could be subject to approximately $30,000 in additional fees in arbitration. The trial court did not consider evidence before it that the defendant Allenbrooke had made an unconditional offer to pay for those fees because the court found that that offer was an impermissible unilateral modification of the parties' agreement. So the court essentially denied the motion and did not or refused to send the matter to arbitration. This court should reverse the trial court for 3 reasons. First, because there is no likelihood that plaintiff will be subject to additional fees in arbitration given defendant's offer to pay. Second, because the offer to pay cannot be construed as a unilateral modification when it was consistent with what the parties' agreement was. And third, because the plaintiff did not put forth sufficient evidence to show what the additional costs would be in arbitration. So the facts, Your Honors, are fairly straightforward. There's not a lot of them. I'll go through them briefly. Mr. Stokes was admitted to Allenbrooke's Memphis long-term care facility in 2016. As part of his admission packet, he's given a 3-page arbitration agreement. The arbitration agreement says at the beginning in big bold letters that you can still receive services if you don't sign. And then there's really 3 provisions that are important here. The fee splitting provision, which is the one that the court relied upon to find the agreement unconscionable, simply says the expenses of the arbitration shall be divided between the parties equally unless others specified in the decision of the arbitrators. And that's the provision we're really talking about here today. It also does, in paragraph 3, have a provision that provides that if any provision of this agreement is held to be unenforceable by reason of law, the provision will be modified to reflect the parties' intention to arbitrate their claims, and all remaining provisions shall remain in full force and effect. And then there is again, I'm sorry, those are the key provisions. But the plaintiff filed his lawsuit in this matter. Defense counsel informed plaintiff's counsel of the arbitration agreement, and plaintiff's counsel would not consent to arbitration because of the expense. The parties brought the issue to the court. Defendant filed a motion to compel. Plaintiff responded by arguing that the fee splitting provision would subject him to unconscionable fees, and he presented 2 affidavits, which you may hear about today. The first one was an affidavit of Mr. Stokes detailing what his financial situation was, his income, things like that. And we didn't depose Mr. Stokes. We don't have an issue with his affidavit. The second issue, or the second affidavit, was an affidavit of plaintiff's counsel, Park Morris. And Mr. Morris, his affidavit simply provided the rates of 4 arbitrators that might handle the case.
Mr. Seiler, let me ask you a question. Of course, the court decided that this provision was unconscionable, and I don't know, I haven't been able to find any Tennessee cases directly on point on this. Perhaps you could direct me to Danny, or Mr. Harvey might when he argues. But there are a couple of federal cases talking about this type of provision, and they also talk about in terms of efforts to offer to pay after the fact, and there seems to be some question about. Well, I mean, they've determined that that's not that in accordance with what Judge Hurd determined was also didn't really change the situation, and the reasoning, their reasoning was that because the agreement was drafted by, for instance, in this case, your client, that the provision as drafted would deter potential litigants. And that's one of the reasons that it was unenforceable. In other words, litigants would look at that provision and feel like that they were going to have to pay substantial fees and essentially giving up their rights to sue in a court where they could file a pauper's oath, perhaps, or whatever, to get into the courthouse. What are your thoughts about that? Those cases are out there. I think one of them at least was cited in both briefs.
Yes, Your Honor. That is obviously a consideration that some of those courts have taken into account. The cases, primarily the Morrison case, the Sixth Circuit case, and some of those cases dealt with specific federal statutory rights. Generally, those were employment discrimination claims and things where, like with Title VII, there was a very strong federal policy at play there against discrimination and against where they didn't want to deter litigants. In this case, Your Honor, I don't think you have the same statutory concerns. This is a.
What about access to justice concerns?
Well,
what about access to justice concerns?
Your Honor, as far as access to justice, I don't see how this agreement denies access to justice or is problematic. For one, and it did not deter Mr. Stokes. These agreements are litigated all the time. Again, I've litigated this particular arbitration agreement multiple times, so there does not appear to be that sort of a problem. In fact, what we find, in my experience, is a lot of the plaintiffs don't even recall signing the agreement. They still go forward with the litigation. So
you wouldn't be here if it wasn't a problem, would you? You wouldn't be here if it wasn't a problem.
That's fair enough, Your Honor. And that's the issue. Those cases, there are specific federal statutory rights in some of those cases that you do have that concern with. Here, I don't see the concern being present. You just don't have that same sort of statutory right, and you have a very strong Tennessee policy and the Tennessee Arbitration Act and the Federal Arbitration Act, both of which also have their own strong policy reasons that would require enforcement. And I think that the best approach is the green tree approach, which the Supreme Court laid down and we talked about in our brief, which is you look at the plaintiff has to put forth some evidence of the burden, and then has to show there's a likelihood of those costs actually being incurred. So admittedly, Your Honor, there are cases out there, but I do think those cases don't exactly fit this situation because we're dealing with a different kind of claim. And I just, practically speaking, I don't believe there's a significant deterrent effect with that one sentence.
Let me ask you this, and you can, if this agreement had been drafted on the front end such that a plaintiff, that there was not this cost splitting agreement in there. In other words, Allenbrooke agreed to pay all of the cost of arbitration on the front end in the agreement. Do you think we'd be here today?
Your Honor, I do think we'd be here today somehow. In my experience, very rarely do the parties agree on this issue, honestly. And this is one of those situations with a nursing home admission. There's always an issue with regard to the authority of the person who signed, again, just due to the nature of the situation, with often the person who needs the services being in the hospital and a family member trying to admit them in a lot of the situations. They certainly could have drafted it to split fees on the front end, but I do not see there being a problem with the situation working out as it is here, where a plaintiff raises a concern in Allenbrooke, where the defendant has the opportunity to offer to pay. And it would seem to be to go too far to require that a party offer to pay the fees in every arbitration. There are some cases where the party is very able to pay the cost of arbitration. But Your Honors, the key concern here, and I think the real crux of the case, is Greentree. It requires that the party show a likelihood of, or that the plaintiff rather show a likelihood that there's going to be unconscionable fees in arbitration. In this case, there is no likelihood because Allenbrooke offered to pay. Plaintiff has not put forth any scenario where Allenbrooke wouldn't pay. Again, there is no likelihood of costs. Also, Your Honors, the court also found that the offer was a unilateral modification of the party's agreement. And just 3 quick points on that, Your Honors. It's not a modification of any kind. We offered to relieve a burden that he indicated he couldn't comply with. It's not a modification. Secondly, I've been unable to find any case where this argument was raised or successful, where an offer to pay was construed as a unilateral modification. It's just not consistent with the multiple federal cases that have looked at a fee splitting provision and the defendant's offer to pay.
Marson stands for the fact that this after the fact offer to pay was not allowed, wasn't it?
Your Honor, yes, there are cases where they have disallowed an offer to pay. What I was saying is there aren't cases where, to my knowledge, where there has been a court has found that the offer to pay was a unilateral modification. There are, to be sure, cases out there that still decline to enforce the arbitration agreement. For example, if the offer to pay is conditional, and there are the case that you mentioned where they found that the offer to pay at the end was not sufficient. But in this case, Your Honor, the trial court did specifically find that this was a unilateral modification, and the parties' agreement actually provides, as I mentioned at the beginning, that the agreement would be modified to the extent it needed to be modified to be enforceable. So on the front end, Mr. Stokes did agree that it would be modified if necessary. And secondly, the agreement also provides that the arbitrator has discretion to determine the costs. So it's not a modification. Allenbrooke paying the fees is completely consistent with the terms of the agreement. And then lastly, Your Honors, just briefly, Greentree is clear that the plaintiff does have a burden to put forth information and evidence of what those costs are. In this case, Mr. Stokes put forth evidence on his income, but the evidence on what the fees in arbitration would be is lacking. Plaintiff's counsel, Mr. Morris, filed an affidavit, and that affidavit simply listed forth the rates of several arbitrators. There's no evidence other than the argument of counsel that sort of connects the dots of what the cost would be. So, Your Honors, in this matter, the federal law is clear. The Tennessee law is also approved of Greentree in those cases we've cited, Trigg and Rosenberg and Hill and Pyburn, that are cited in our brief. And in this case, there's no real dispute about what happened. Defendant offered to pay. That takes away the likelihood that plaintiff will be subject to fees, and this court should reverse the trial court. Thank you.
Thank you. We'll hear from Appellee's counsel.
Thank you, Your Honors. Good morning. May it please the court. My name is Phil Harvey. I'm of the Memphis Shelby County Bar, and I represent Mr. Tkach Stokes. I believe Mr. Stokes is watching live this morning, so I did want to pause and thank the court for this opportunity. Despite the circumstances, we're grateful for the ability to keep things moving despite all the delays that we're all facing. We're asking the court to affirm the trial court's decision. Judge Hurd got it right. And Mr. Stokes is asking to remand the case for trial. This case is very important to Mr. Stokes because the question posed by Allenbrooke is very simple. Can a corporation put whatever they want in the contract so long as they promise to change it to something fair if a lawyer gets involved? And if there were any doubt that that were the precise and solitary issue, this court doesn't need to look any further than volume 3 of the record in pages 29 through 33, where at the hearing before the trial court, counsel for Allenbrooke emphasized that their entire argument rested on their April 1st, 2019 offer to pay. On those same pages, Allenbrooke stipulated to the evidence, which now they would like to litigate on appeal. They stipulated that Mr. Stokes was not able to pay his share, and they stipulated that the cost of the potential arbitrators were as set out in Mr. Morris's declaration, and that the case could go on for as long as 1 week, which is where the $28,000 figure comes from. On the low end, the evidence in the record set forth by declaration and not objected to by opposing counsel. On the low end, it sets out the difference between litigation and arbitration as coming to approximately $4,400 for Mr. Stokes. And with those undisputed facts, I think the timeline here is very important because Allenbrooke knew Mr. Stokes couldn't afford to pay his share of arbitration when he was admitted to the facility. He was paralyzed from the waist down. He was disabled and could not work. He needed round-the-clock nursing care, and he received state benefits to pay for his stay at their facility. Yet they did not offer to change the cost provision when he first signed it in June 2016, nor when they signed it with him again in September 2016. They did not offer to change the cost provision when he was sent to the emergency room with uncontrolled bleeding after one of their nurses attempted to reinsert his catheter, contrary to doctor's orders, nor when both of his legs were amputated and both of his hands, except for one thumb, were amputated. And most tellingly, Allenbrooke did not offer to change the cost provision, even when Mr. Stokes sent out his notice of intent to sue, which was required under the Tennessee Healthcare Liability Act, in part because the legislature anticipated that notices of intent to sue would facilitate pre-lawsuit resolution. Instead, they waited even 4 months after the notice of intent to sue, after the complaint was filed, and then an attorney retained by Allenbrooke said, let me reach out to Mr. Stokes' attorney and try reach back in time and change what happened. This is business as usual. This contract is, as opposing counsel pointed out, they litigate this contract all the time. And it's true that very often, even our firm has negotiated terms different from the written agreement and proceeded to arbitration. But that's really the key here, is that in these other instances, which Allenbrooke brought to the trial court's attention via email that we believe should have been protected by Rule 408, in those other circumstances where the circumstances and client priorities aligned, we agreed to new terms. And yet, in their principal brief on page 7, Allenbrooke complains that Mr. Stokes didn't proceed to arbitration as was set out in his agreement, despite them not even asking for it after the notice of intent to sue went out. And so really it's when opposing counsel protests against looking to cases that examine the plight of other litigants, it's Allenbrooke that brought other litigants into this in the first place. They wanted the trial court to consider the fact that our practice has agreed to other terms with other clients in other cases. And what they're asking for is for permission to keep using this contract. They want the court's stamp of approval to use a form contract with their residents that effectively insulates them from any accountability whenever their residents are of limited means. Because
let me ask you a question. It's my understanding that the trial court found the contract as it existed unconscionable. Is that correct?
yes, Your Honor.
Okay. And the basis for that was what exactly?
That Mr. Stokes had agreed not to pursue litigation and that he was precluded from arbitration because he could not afford it. Mr. Stokes's discretionary income was approximately $30 a month.
Okay.
And
Is that the sole reason, the income of your client?
yes, Your Honor, his inability to pay.
Okay. So opposing counsel says there is what I refer to as a severability clause in the contract. How does that affect the analysis if opposing counsel is accurate in saying that his client's now willing to pay?
Your Honor, I would still argue that they've waived this because they didn't bring it to the trial court's attention, but we did answer the merits of this argument in our brief. And a severability clause goes to sever unnecessary terms for any contract. And Your Honor, the cost provision really goes to the heart of the bargain because our position is that it's perfectly fine and reasonable for a well-resourced, more sophisticated party to offer to pay the full cost of arbitration and bargain with a less resourced party with no business or litigation experience, but they need to set that out. And it goes to the heart of the bargain because splitting the costs is a sensible and reasonable way for two parties to ensure that they're getting a neutral arbiter. The whole purpose, and again, I think we should keep in mind that the Federal Arbitration Act was enacted almost 100 years ago. And it was enacted to counteract a previous unfair scrutiny of arbitration clauses. I feel like at some points, Allenbrooke verges on characterizing the favorable policy for arbitration clauses as to somehow argue they receive less scrutiny. But really, they're just on the same footing as any other contract. And where the contract sets out that the parties are going to obtain a neutral arbiter by splitting the costs of that arbiter. And then the one party says, we want to go back post hoc, unilaterally change that so that we're paying for the arbitrator. It goes to the heart of the bargain because it deprives the other party of one of the most sensible and primary means to achieving a neutral arbiter. And again, it's not that there's no free contract.
I'm not following that argument. Explain to me how that goes to the heart. Are you saying that you don't have any input in hiring who the arbitrator is? Or are you saying that because the other side is paying that arbitrator or those arbitrators that they're biased? What are you actually saying there?
Your Honor, it's just saying that there's a lack of notice. I think a party who's given notice that they're going to have their claims and their disputes decided by an arbitrator who's paid for by opposing counsel could agree to that if they were given the option and notice to agree to it. But when a party is told that they're going to get a neutral arbiter because both sides are paying, and then after the fact, they realize that arbitration is something they cannot afford because they didn't have the business sophistication to know that on the front end, that is what makes us a modification not subject to the severability or modification clause.
I'm not following that analysis there.
If one party gets to choose and pay for the arbitrator, there's a danger that there's not the
Are you saying that you don't have any input in the selection of the arbitrator?
No, Your Honor.
then how is one party selecting the arbitrator? The only thing one party is doing is paying for the arbitrator.
Yes, and if those were the terms that had been bargained for, I think it would have been reasonable. We wouldn't be here today. And in fact, they put those terms in other contracts. We see many of these contracts, just as Mr. Siler does.
Let's confine our discussion to what's in front of us here, unless those other contracts were in fact in the record.
Yes, Your Honor. In this contract, the arbitration provisions provide that the parties shall divide the cost of the arbitrator equally. This is a reasonable means to ensuring that both parties get a neutral arbiter. Again, if the parties had noticed that one party was going to pay, or if
Why is notice important here?
Because the unconscionability analysis requires the courts to determine whether the terms were so one-sided that no reasonable person would offer them and no honest or fair person would accept them. That is conducted under the essentially a totality of the circumstances under Hahn v. King. It's all the facts and circumstances. And what that
So when does this analysis take place? Are you saying that before any arbitration agreement can be signed that would basically require the parties to share a cost, some analysis has got to be done by whom over whether that the parties, both parties have the ability to pay the arbitrator?
Your Honor, if a party raises it, yes, because unconscionability is a formation issue for the trial court. And the case law in Tennessee is clear that requiring parties to arbitrate whether or not they had agreed to arbitrate would be circular, but also that unconscionability is a formation issue, just like authority to sign. And so, but there's, in Trigg v. Little Six Corps, which is a reported case from the Tennessee Court of Appeals. It was a retaliatory discharge brought by an executive with a six-figure salary and a $1.5 million severance bonus. He raised a cost-based unconscionability argument and was rightfully laughed out of court. So this has become, I believe, a factually intensive analysis in this case, but in many cases it's easily disposed of. And so this is really, the best case in Tennessee, or the most on-point case in Tennessee, is Hill versus NHC Healthcare. It is an unreported Tennessee Court of Appeals case. I believe permission to appeal was granted, but it was never taken. And it appears it's cited throughout our brief. But in Hill versus NHC Healthcare, a nursing home resident died after she was disconnected from her oxygen. Her family brought a lawsuit. The trial court did not enforce arbitration based on inability to pay. And the Court of Appeals affirmed the trial court, although rejecting a multitude of the plaintiff's arguments for why the arbitration clause should not be enforced. The court found that it was an adhesion contract and that it was unconscionable because of the cost provision. Now, in this case, we don't have an adhesion contract, but that's really only one factor in the analysis because, as we know from Berkazinski, adhesion contracts can be conscionable. In this case, we have a non-adhesion contract that is unconscionable because Mr. Stokes is precluded from litigation because he's agreed not to pursue it, and he's precluded from arbitration because he cannot afford it. Allenbrooke knew this at the time he signed it, and they shouldn't be given permission and the stamp of approval to continue using a contract that accomplishes this for them whenever they have a resident of limited financial means.
You say they knew it at the time that he signed the contract.
He was on TennCare.
What's the evidence in the record?
The evidence is on pages. Well, the evidence is that he was on TennCare and disabled and could not work. Allenbrooke is a sophisticated business actor with experience in litigation. Mr. Stokes was not. And none of this evidence was contested at the trial court, they rested solely on the April 1st, 2019 offer to pay.
Thank you.
Thank you.
We'll hear from the appellant. You're muted, Mr. Siler.
Sorry about that.
That's no problem.
To me every time. Thank you, Your Honors. May it please the court. Just a few points in regard to the waiver argument that is addressed on page 12 of our reply brief. We did argue that to the trial court. It's in the record at volume 2, page 197. In our supplemental brief for the trial court, we argued that even if Allenbrooke's offer to pay costs could be construed as a modification, such modification would be entirely consistent with the parties' agreement, which specifically contemplates that it might be modified to the extent necessary to enforce the parties' intent to arbitrate their claims. So we did not waive that argument. That is addressed in our reply brief to this court. Secondly, as far as he had no notice argument, Your Honor, he did have this contract. He signed it twice, actually. He had the opportunity to review it and to read it. As soon as he raised this issue, we offered to pay. Again, as soon as he raised it, we offered to pay. Briefly, counsel mentioned the Hill decision. The distinguishing things about Hill, there was a contract of adhesion, which there's not in this case. Hill did not involve an unconditional offer to pay. And Hill also found that there were, I believe, approximately $18,000 in upfront costs just to get the arbitration filed. There's no evidence of any of that in this case. As far as the other points, there's no evidence in the record, Your Honor, that other litigants are deterred or that we've been effectively insulating ourselves, or Allenbrooke rather has, with this contract. Again, this arbitration agreement is litigated all the time. The key factor here is the likelihood that plaintiff will be subject to additional costs. And there just isn't any evidence in the record of that given our offer to pay. So we'd ask the court to reverse the trial court and refer this matter to arbitration. Thank you.
Thank you, counsel. We will attempt to get you an opinion as quickly as possible. We appreciate your participation in this process. Again, we want to thank Mr. Hibner and his staff for putting all this together. He's the mastermind behind it all and does a wonderful job. And also the AOC staff who continue to make this process work. Mr. Hibner, if you will recess court until the call of the next case.
This honorable court is now in recess until 11 a.m.